Hello guys, and welcome to another episode of my lecture. Today we'll be talking about the Res Gestae doctrine under the common law. So then, what is Res Gestae? Let us move on. Under the Res Gestae, evidence may be received even though it infringes the rule against hearsay evidence. Now, before a piece of evidence, usually a statement, is held admissible as forming part of Res Gestae, then there are certain conditions under the common law that must be fulfilled. Number one, the first element is that they must relate to the act. That means the statement which is being spoken must relate to the act, that is the issue in question. Number two is that they must be made by the actor, while number three is that they must be roughly contemporaneous with it. Number two meaning that they must be made by the actor, meaning that the statement must be made by the actor, while number three is that they must be roughly contemporaneous. The statement must be roughly contemporaneous with the act. Don't worry, I'm going to explain what all those means. Know that my first and second element will be discussed in this video, while the third element will be discussed in later video, because the third element is divided into two sub-elements: the former position of the common law and now the current position of the common law. So let's talk about the first element, which means that the statement must relate to the act. Now, this means that the statements must relate to the act that they are accompanying, like I've said. Now, the locus classicus for it, and you should know that when you are quoting this in any exam, you must quote the locus classicus: AGASSIZ versus London Tramway Corporation Limited. Now, the fact, just after a collision in which a tram car was involved, an indignant passenger said to the driver, "This fellow's conduct ought to be reported." Now, the conductor retorted, that means responded to the passenger. He had already been reported 4 or 6 times today. He is a new driver. The court rejected evidence of this statement as forming part of Res Gestae on the grounds that it did not relate to the collision which was an issue, but to past act of the driver. Also see the case of R versus BLISS. So you see, now we are talking about a statement. What was the statement that is forming part of Res Gestae? He has had previous collision about 4 to 6 times. That's what the conductor said. That's the person who was supposed to conduct the bus. That's what he said. And then he said he was a new driver. Now, there is a particular act, let us say the 7th act, that just happened. There was a collision. A passenger in the 7th act, the 7th collision of the day, said, "Oga, how far now? You want to kill us?" And then the other party, that's the conductor, was saying, "Oh, I saw this guy just the jam any car way, see anyhow. I don't know what's wrong with the guy." The court said, you see the statement of the conductor, it did not relate to this particular act. He was talking about previous acts. Do you understand? We are not talking about this one. When you are talking about the rules of Res Gestae, which is a statement that you are coming to tell the court that was said by a person, that statement, the first rule is that that statement must relate to that particular act in question, not relate to other acts. Do you understand what I'm saying? It must not relate to other acts. It must relate to this act. So does that statement relate to this particular act? If it does not, then you quote the case of AGASSIZ versus London Tramway Corporation to say that it is not admissible as forming part of Res Gestae. Do you understand? Now let us go to the second rule. The second rule is that it must be made by the actor. Now, for a statement to be admissible as forming part of Res Gestae, it must have been made by the actor. Now, this condition would appear to no longer be valid in view of the decision of R and FOWKES. In this case, on charge of shooting a man through the window of a room where he was in company of other persons, the son of the victim was permitted to give evidence that just before the shot was fired, he saw the accused through the window and that he, the witness, had cried out, "This is butcher." Now, the court held that the evidence of this exclamatory mark by the son was admissible. Now, when they got to court, they were saying that, oh, we have the shooter and the shooted. The shooted is the person that was shot. Now, the shooter did not say anything. The shooted did not say anything. It is a third party, in this case, the son of the shooted, who said this is butcher. In this case, that should not form part of res gestae because the son is not the actor in the script. Do you understand? The actor here is the shooter, Vin Diesel, and then the shooted, whoever it is, you know. Now, it wasn't either Vin Diesel or the other party. Anybody that is not the actor in that particular script cannot be said that his statement would form part of res gestae. Do you understand? So here the court said no. When we are looking at the situation, we are looking at everything as a whole. We are not only looking at the actor. The former position is that, oh, the actors must be the one to speak, and then their statement will form part of res gestae. But this one is saying no, and that's the case of R and FOWKES. He said no, even if you are not there, another third party was there and that person made a statement. Another person or that person himself can come and give evidence that he said he was able to recognize at the time of that particular incident that this is the person that did this. Do you understand what I'm saying? So those are the first two rules. Number one is that the statement must relate with this present act, not previous set of acts. Do you understand? It must relate with this one. That's number one. Number two is that the statement must be made by the actor, but that position has been reversed under common law, and now even if you are not the actor in that particular scenario, you can, if you made a statement, testify to that statement which you made in court. The authority there is R and FOWKES. So in my next lecture, I'll be teaching you what is the third element of res gestae doctrine under the common law. See you in my next lecture.